So without further ado, so I'm Lane Fisher. I am not wearing a badge, but I am here to help you, here to serve. We have spent hundreds of thousands of hours, Brad Fishman, myself, Ryan Hicks, Zach Fishman, Jerry Fishman, trying to put together an amazing event for you. We try to do whatever comes to your mind first. As when you think of another event, we try to do the opposite or more or 200% of what that is. And that is incredibly labor intensive. We try to make the experience special. For each of you, we're all here for you to try to make sure that you make the connections that will help you get your businesses to the next level. If there's somebody you see on that list, which we have pictures on, who does not have the app downloaded? Just me? No, I have it downloaded. You will not survive at this event without the app. It's an app that we developed. It's proprietary to us. It will remember you when you come to our next event. You can look back at your past events, but it also has the schedule, which sometimes we change on the fly. Where? In the app. You gotta have the app. So the app has all the places, it has all the dinner places, it has all the times in it, it has the legend for how to find roundtable hosts. So please download the app. And Ryan, are you leaving that thing?
Yes.
Okay, okay.
I need to say a quick word. So we just spun up the QR code probably 2 hours ago, and there's a limit on it. So I'm going to get a new one that doesn't have a limit if it takes you to another place so that you can scan and enter your information. I will work on that, and then we'll redistribute that back out.
The Director for Technology. Okay, without further ado, let me hand it off to Joanne Kenny, my partner.
All right, good afternoon. Welcome to Springboard 2024. Woo! I'm excited to launch things off today with a really important session. I don't know if you asked this. If you did, I didn't pay attention. How many of you have been through sales compliance training? Okay, a few. Great. Great. Well, it's great to have all of you in the room. This is a really important topic, especially now with responsible franchising and franchising being the target of the federal government is reviewing the rule and contemplating changes in the rule, and there's just a lot of activity out there right now. And so it's very important to make sure that if you're involved in the franchise sales process, that you're educated on what it means to grow responsibly under the law, right? There are regulations, rules that govern the franchise offer and sales practice, and that's what we're going to generally cover today. And I'm Joanne Kenny. I'm going to partner with Fisher Zucker, and I've been practicing in the franchise space for over 20 years now. So I've seen it all. I work on the transactional side, on the litigation side, and I will say that probably over the last year, I have received more demand notices, and Frank, you can back me up on this, more this past year than I've seen maybe collectively in my entire years of practice. So there's something going on out there. There's something in the water, and so it's very important that you be aware of what these rules are, because these franchisee attorneys are digging into that pre-sale process and they're fleshing everything out. So it's very critical that you understand what the rules are and that you play within them. So with that, I'll switch off from this barcode. This is just our general agenda, and I'll stand up because that'll be easier here. Okay, so franchising, we're regulated at the federal level. There's the FTC rule, and that rule governs in the entire United States and its territories. Why do we have it? Well, years ago, there were franchise offers and sales made, and they were fraudulent. People were selling business opportunities that didn't exist, and people were losing their livelihoods. And so whenever you have a lot of fraud and deception going on and injury happening out there, you have the government step in. So that's why we have our FTC franchise rule. It was enacted to prevent deceptive and unfair practices in the sale of franchises. So it requires disclosure to prospective franchisees. You have this long, comprehensive disclosure document that you're required to prepare and give to a prospect. It includes comprehensive information about the franchisor, about its principles, its background, how much the franchisor estimates it will cost to open the franchise business. It includes the franchise agreement itself, summary of the terms. If you are involved in franchise sales, you need to read your FDD and be familiar with what's in it. Disclosures are really important. They're important, one, because the law requires that you give them, but it sets the tone for the relationship. It's designed to give the prospect the material information they need to make an informed investment decision. And so it's important that you know what's in it so that you know how to talk about it, because this is really setting the tone for the beginning of the relationship. And we're going to get into discussions on financial performance information and what you can do and what you can't do, and why your words matter. Your words matter in the franchise sales process. Just because you said it and it's not in writing doesn't mean it can't come back to bite you. I just received a demand notice yesterday that talked about what people said in the sales process. So you really need to be very careful. The franchise rule, as I mentioned, is currently under review. We anticipate that there will be modifications to the rule. Nothing happens fast, and if they move as fast as New York and California on your registrations, maybe it won't happen ever. So, and they're also examining regulations related to post-sale, so relationship-type issues. Key items in the FDD that come up, you have item 1, which is your history. Item 8 talks about derived revenue and required purchases. Item 5 is your fee section, all the fees that are paid to the franchisor or an affiliate before signing the or before opening. The estimated initial investment, really important, and item 7. Item 19, we'll spend a lot of time on that. That's your financial performance representation section. And then there are other items that come up. Item 10, financing. 11 is very comprehensive. That talks about the franchisor's obligations, training. 12, territory. Your franchise agreement will maybe award protections to a franchisee in an area. And so those disclosures will cover a description of what the franchisor offers protection-wise. Item 15 is becoming a little bit more important. I think this talks about the obligation, whether or not the franchisee is obligated to participate in the operation of the business. Is it owner-operator? Is it manager-operated? Is it semi-absentee? That term is used very widely in the franchise sales process, and it's triggering a lot of issues on the legal side. What does it mean? What doesn't it mean? What does the prospect think it means? What do they say they think it meant after they bought and they're not happy? Item 20 talks about your franchise history, so how many franchisees you have in operation. It gives a 3-year look back, so how many you have open, how many closed, how many transferred, how many were terminated over the past 3 years. So the FTC rule requires that you give the disclosure to the prospect and that you wait 14 calendar days before you can either collect a signed agreement or any consideration. So no fees, no collection of checks until after you have that 14-day waiting period expire. Sometimes I have clients reach out because the prospect's sophisticated, they're really prepared, they've reviewed the FDD, they're ready to go, they want to waive that 14-day requirement, and they ask if they can do that, and the answer is no. You can't waive it. The law doesn't allow for you to waive it, even if the franchise prospect wants to waive it. So you need to make sure you've got that nice, clean, 14 calendar day period from the date you give the FDD to the date you sign it, and don't count the first day or the last day. So there's a nice, clean 14-day period in between. So it's really 15 days, yes. And the old rule, so the rule was amended in 2008, and the old rule required that you give the FDD at the earlier to occur of the first face-to-face meeting with a prospect, or 10 business days before signing. I bring that up because there are some states that have statutes that regulate the sales process, and they've held on to that old requirement or some piece of it. So we'll get into those specifics in a minute. There was a change in 2023 that interfered with a closing process that most franchisors followed. Most franchisors, all that I've worked with, use pre-closing questionnaires. Pre-closing questionnaires are questionnaires or acknowledgments that the franchise prospect completes to essentially establish that no rules were broken in the sales process. It would ask things like, have you received your FDD? Did you read your franchise agreement? I acknowledge I understand my franchise agreement. I understand that there's no promise of success. I understand and I represent that nobody told me anything regarding financial performance outside of what's in the FDD, if there is an item 19 in the FDD. And those questions and answers to those questions are extremely important, or were extremely important to franchisors, because as you grow, your sales force grows, and you're not sitting in the room in every discussion with each prospect. And so it's possible that somebody messes up, whether it's intentional or not. You want to know about it. Well, now the regulators have determined that most of the questions, those that are really meaningful, are prohibited. You cannot use them in registration states, which we'll get to, because they consider them to be disclaimers. Why do they consider them to be disclaimers? Because if I receive a year from now a demand notice from one of those franchisees who completed their questionnaire and acknowledged that nobody said anything that they shouldn't have, that they understood that they could lose their investment, that they understood that there was no promise of success, but fast forward a year later and they're not happy with how things are going, the demand notice would say that someone made representations in the sales process. So somebody said something they shouldn't have, or there was a PowerPoint that included a slide that talked about success, performance, revenue, how long to break even. And those questionnaires were extremely critical in refuting those allegations, because you completed a questionnaire that said nobody made those representations to you, and now here you are, fast forward a year later, claiming that someone did. So they were extremely important, and now you can't use them in registration states, and so now you have to hope that nobody messed up in the sales process, because you can't ask whether or not they did. And so franchisors are at a disadvantage there. So extremely important to make sure that your sales team is trained so that they don't make those mistakes. It's not always obvious, and the questions naturally come up especially about earnings in the sales process. And so how you answer them is you need to be very careful.
So is the best practice to take them out?
So the best practice is not to use them in the registration states. The federal law has not changed. This actually isn't a new issue. If you're a dork like I am and you read the FTC's rule and the statement of basis and purpose, it explains all of the exchanges that went on between the attorneys before the rule was changed, and what was considered, what was proposed, what the arguments on both sides were with respect to different issues, and where the FTC landed. And this issue was brought up then, and there were complaints about representations being made in the sales process and being cleansed away through the questionnaires and through the franchise agreement acknowledgments. And the FTC...
You can only be telling the truth one time, right?
Right.
Either nobody made any representations or warranties to you, which is what you said at closing, or everybody made representations and warranties, which is what you said in the lawsuit, right? So these things were incredibly damning, and it made people feel personally compromised when you have them in a deposition, asking them if they're lying today, and this is their line or that line, and nobody likes to be accused of lying, and it was a tool that limited claims. And so when we first started having it down altogether, that's much more dramatic than losing it in the registration states, that is at least a smaller subset. But the loss of those things will be felt for years to come.
That's right. That's right. And if the FTC changes the rule and makes it clear that they're going to adopt NASA's position on this, then you won't be able to use them anywhere. But the rule did consider it, and where they landed was that everybody needed to include a provision in their franchise agreement that said nothing in the franchise agreement could disclaim any representations made in the FDD, which is where they should have landed, right? Because you're required to give this pre-sale document. You can't then disclaim any representations you made in that document through the agreement that they're required to sign.
But we're just saying, does anybody give you any information that wasn't contained in the FDD? Like, I can argue it's totally consistent with that. The point is, you have regulators that are making more generous, more liberal interpretations to have the rule fall out where they want it to fall out, right? And that's politics.
That's right.
Did you get a video statement from them prior to signing?
So that's interesting.
Can you get a video statement? So the NASA, their statement indicated that you cannot. You cannot conduct a closing interview and ask the questions that you're not allowed to ask in the questionnaire. And so they've covered that.
We've had some very intellectual discussions about how you might have 4 people on a Zoom call. The salesperson, the prospect, and the broker. Let's assume those 3 people are involved. And I say, broker, did you say anything outside of the FDD to this person? Broker says no. I say to the franchise salesperson, did you say anything outside the FDD to this person? And this person says no. I believe that if you were just quiet in the middle and said nothing, knowing that those statements were not correct, that will also be damning on you, even though I'm not asking you one of the violent questions. So don't worry, we're still trying to figure out how to get another bite at this apple. But
Yeah, franchisors are getting creative around that, right? You can record your closing interview and make the statement that, we pride ourselves on franchise sales compliance, and our people are trained, and they're not permitted to make any statements about earnings or performance or projections, except what we have in our item 19. And so if there have been any issues in the process, we want to know about it, but you don't need to actually ask them whether or not anybody said anything. And then if they don't say that anybody said anything, and you've got that recorded, well then why wouldn't they speak up then? That was their opportunity to do that. So in addition to the federal law, franchising is also regulated at the state level. There are states that have enacted their own statutes that govern the franchise offer and sales process, and some of them require that you register your FDD along with a bunch of other forms before you can have any activity in that state. You wait for approval from the state before you can send your FDD or having any meaningful discussions with prospects, or obviously enter into an agreement with a franchise prospect. So we've got the 14 registration states listed here. Those are the states that you require that you submit that filing and wait for approval before you offer or sell in the states. And some of them are fast and easy, and some of them are very, very slow. Anybody have experienced frustrations with franchise registration and how long it takes to get approved? Yes. And it's often outside the control of the lawyer. A lot of these states are overwhelmed. They don't have enough people working for them, and so they've got stacks of applications or online applications, and they just take forever to get to them. There are also business opportunity states. They're easier to comply with. If you've got a federally registered mark, or even in some instances a state registration, you're exempt from those requirements. And others require just one-time filings. So we've got a summary here. You've got Kentucky, Nebraska, and Texas are one-timers, annual filings, and Florida and Utah, simple. And then you have some other states that may require you to do something if you do not have a trademark registration. Important that you know which states are regulated, because you're going to be dealing with prospects who either live in those states or are looking to open in those states. And so it's important for you to know which states require you to have a green light first. I'm assuming you have some type of compliance program in place, some connection with your franchise attorney so that you're aware of where you're green and where you're red.
And I think even in the course of you knowing what states you need to investigate, you can ask the person, right, where are you domiciled, where are you a resident, and where do you want to operate? Those should be the 3 data points. But sometimes they don't tell the truth.
Or sometimes they have they live in multiple places, right? So, and sometimes their residence is different from where they're looking to operate, and it may be that where they live is a registration state, and if you're not registered there, that will be an issue. So for example, we had an issue with a franchisor that had a prospect who was looking to open and operate in a non-registration state. Let's say it was Arizona, and the prospect lived in Washington. Well, he didn't actually live in Washington. He lived in maybe Nevada, but he had another house in Washington, and maybe there was something favorable about tax laws or something there. And so there was a residence that was held in Washington, but the person didn't really live there. They were wealthy. They weren't even looking to open there. They were looking to open in a different state. And so when they completed the application and their driver's license was taken, you have that Washington address appear. So fast forward, they sign the agreement, they're gonna operate in a different state, things go sideways, they hire a franchisee attorney, They go through the file and they see that Washington address. That's like magic. Because
Let me show you what you have to look at. Everything, right? You get a fax cover sheet from Washington, you got to stop and say, why is it? I don't even know 207 is why. I got to Google it to see that it's Washington. You will be tagged to know everything that passes through your hands or email box, and it's so obvious when you see that fact that says the state of California on it somewhere. Like, it's just crazy, but you're held to know everything that came through your hands. So you fill out an application, no registration states are implicated, but they send you a thing. It could have been just an email from a vacation spot, but you have to know. And if they own the house there, that makes them
yeah, and the franchisor got hit with a pretty bad judgment in that case. So just because they were not registered in Washington at the time. And so the Washington statute required that you be registered in order to offer and sell to a resident. They weren't, and so they got hit with a pretty big judgment. So
I have a question for you. Is
Yep.
the same folks that ignore all of our registrations, the ones that, do they also have investigative and sort of prosecutory functions?
they do, or they'll refer it to the Attorney General in their state to investigate. So if there are issues or concerns with your sales practice and somebody calls to complain about you, and this has happened with clients, we would receive an investigative notice that the state is looking into your compliance practices, and they'll ask for every prospect from the state that you dealt with maybe over the past 3 years, copies of all the FDDs you provided to those prospects, copies of all the receipt pages you collected, copies of the franchise agreements, and evidence of the deposit of the initial franchise fee. That way they can check to see if you were registered at the time you gave the FDD, if you were registered at the time you collected the fee. If you collected the fee, was there a deferral in place? So they have a very easy method of determining whether or not you violated the statute. And if you did, you could get fined per violation. We'll get into the ramifications of violations a little bit later.
You could be dead right and want to go take one of these examiners or take one of these states on, but anybody who went to law school is going to try to talk you out of it because you'll miss that whole year in California while you're trying to vindicate your rights. Well, those investigations often come with a stop order as the first piece of business. So I don't know how many prospects you had there or hoping to have there or what your critical mass is. All those things stop. So what happens is you have a hard, but I was totally right. We did it just like we talked about. But the answer is like you have to resolve these things or you can't move forward.
Right. Also, I mean, they'll also look at your item 20, and your item 20 lists where you have franchisees, and your franchisee list is attached to your FDD. So if you register in Maryland and you were never registered there previously and you're showing franchisees in Maryland, well, they're going to identify that and then ask you questions about that. So very important to make sure that you have a franchise sales compliance program in place, someone in charge of checking all of these items before the franchisor countersigns any agreement, so that you can determine whether or not something went wrong or if there was a registration state that was triggered and somebody accidentally missed it. Well, now you're catching it before you sign, because once you sign, the cat's out of the bag. There's nothing that you can do to completely cleanse that at that time. There's some corrective measures that we can try to take, but you're never going to be completely cleansed. So make sure that you've got a sales compliance team in place, someone that's been trained on all of these issues. They should have a checklist in hand that's run through before each closing, before the franchisor signs off on each deal.
So let me tell you the likely part that no one gets right, and I think that if we guessed it, I hope we'd say the same thing. It's the list of franchisees. Nobody can give us an accurate list of franchisees or a column with numbers in it that adds to the top total on the bottom. Nobody.
It really is amazing. He's exactly right.
It's Montessori level. It is unbelievable, but nobody. And if some people sell one deal a year. Like, it's not even, I can do it in my head.
Well, so it's good. We provide a template spreadsheet that would list all of the items of information that we would need to make sure that the item 20 is populated correctly and that the franchisee list is displayed correctly. So you need to know when the person signed, when they opened, where they are, obviously. So there's a way to structure your data so that your attorney takes less time on your update, which will be cheaper, which I'm sure all of you would appreciate. Or maybe you could even take a stab at it if you've got nice, clean records. We always welcome that. Well, when they opened, how many in each state, broken down by state, yeah, that kind of detail. All right, the FDD is not set in stone. You issue it every year. It must be updated. It must be updated to capture all of the updates that happened through the prior year. And the FTC rule requires that that update be completed by 120 days after your fiscal year end. So for most people, that's April 30. That's why you've got that crunch of busy season for your franchise lawyers. Every franchisor, most have a fiscal year end of 12/31, are in the process of getting those documents updated. So also good for you to know that if you're on top of your game, you can start getting that information ready, work with your lawyer to get that update information going towards the end of the year. Don't wait until, certainly don't wait until March to start gathering that information. You can start preparing for your update in December and be ready to provide your attorney with all the information they need to complete that update. Because if you're finished early and you register before April 30, well, now you're not in with that giant herd. So the applications may move forward faster. It depends on how early you get them in.
So, did you have a question? Do you want to answer it or not? Yes. Okay. So this is supposed to be a question. This is supposed to be a very informative question and answer session. We help you get down to the things that the questions that you have. I mean, we could go on for 4 days here. Oh, good question. Look at that.
Good. Okay. What's your question? Go ahead.
So what if the franchisee, when they sign it, like they have to show their driver license? For example, if they are in Atlanta, and then do we count the address, but later on he changes his mind, he wants to open it like a registration state? Like how do we work on those cases?
So your intake form should identify where they reside, which should match with what's on their driver's license, and then where they're looking to operate. And they could be 2 different states. And you need to make sure that if the answer to either question triggers a registration state, that you're registered in that state before you move forward, before you give an FDD. Before that. Mm-hmm.
So what if we give the FDD already? I'm registered in Atlanta, and then we give the FDD already, and he changes his mind afterwards. He wants to open in other states that is a registration state. Then how do you do that? Can we treat it or like?
Well, you've already disclosed, and originally the prospect was looking to open in a state that was not a registration state, so there was nothing wrong with that. But once they indicate that they're interested in opening in a registration state, then you're going to need to pause on the process and get registered there and then redisclose and wait the period, which could take a long time, and time kills deals, so that would be unfortunate, but that's what you would do. Yes?
So on that with comment time kills deals, do you know if there's any local state legislative action around state registration offices holding franchisors hostage to their understaffing issues and hamstringing us to do our business? And they're the kings and the queens,
Yeah.
but you have no recourse, it seems.
No recourse. You're right. I'm not aware of any concerted action to try to get ahead of that, but that certainly is a concern. And I find that I have applications sitting for weeks, sometimes months, and I'll reach out to the department if there's a phone number, if I can even reach a human, and the answer is often, that we're busy and we'll get to it when we get to it. Now, there are some state statutes that allow for it to be deemed approved if a certain period of time goes by and you don't hear anything. But there are only a few of those. And so you're really at their mercy. But you're right. You have deals, you have prospect, you have leads, and you can't do anything with them. And I share that often with examiners. And they say there's nothing we can do. Now, usually when I make that call and they say that, within the next week I get something from them. But yeah, I share your frustration. It inhibits business growth for sure. Yes? So he's asking, if you're in a situation like that, is there anything you can do? And one thing that you should explore is whether or not there's a franchise, an exemption to the regulations that would apply. So under the federal law, there are some exemptions that certain types of prospective franchisees, thank you, you would not be required to comply with the federal law. Now that's a disclosure issue. I'm assuming you've got a disclosure document, so maybe we don't really care about those. But if you're in a registration state, the registration state may have some exemptions built into their statute. And so certainly reach out to your attorney to see if that's something that may be workable. Maybe they're a sophisticated franchisee, they've got an enormous net worth and lots of business experience. It may be that an exemption does apply. Yes?
Exemptions are the most unexploited part of franchising. But it's great for you for bringing it up here. It won't be everyone. It's not a real way to scale, but there's often a way to get at least some additional ones done, depending on whether they qualify and what state you're in. But
That's right.
always be asking that.
And some states require a filing in order to have that exemption memorialized, like California has specific forms that you need to file in order to have that exemption recognized. But you should even have the prospect fill out an acknowledgement form that establishes that they meet the criteria of whatever that exemption is anyway, so that you have that for your file as well. Yes? Yes?
If you don't qualify for exemption, can you enter into a licensing agreement?
Oh, goodness.
And/or defer royalties until such time as the state gets around to registering your FDD and then retroactively?
I have a lot of cleanup work with people who come to me because they weren't ready for franchising before, and so they went down the licensing model path. Except the problem with that is that the licensing model path is franchising, and so then they come to me with a whole host of problems that we then need to clean up, and that becomes expensive and time-consuming, and then you have to confess your sins to the registration states, and that is not a fun process. So I wouldn't recommend that. But your other point was deferring fees. Now, that's kind of tying into the exemption that it's not a franchise because they're not required to pay anything, let's say, for 6 months. Not all states recognize that exemption, so you need to be careful if it's a registration state and you're looking to proceed there. And you have to be careful there are no hidden fees if it exists and you're looking to wiggle within it. You need to be careful to make sure that you actually meet it. Yes? No, the FDD, the federal law requires that you update it every year. Now, the federal law, once you prepare your FDD and it's in compliance with the federal law, you've got your audit attached and you're ready to go, it's self-executing. It doesn't get sent anywhere in the federal government for approval or a stamp of acknowledgement. It's self-executing. But the registration states will require that you submit the application for the renewal. And then in many of those states, you're going to have to wait for them to approve you in order to recommence your franchise offer and sales. So you'll go dark in some areas.
As far as the audit, what if you're brand new and you don't have anything to audit? Like, that was the question that came up.
If you're brand new and you don't have anything to audit, you do have something to audit, and you do. Well, there's a phase-in under the federal law for new franchisors, but if you're going to have any activity in a registration state, most of them don't recognize that. And it's good practice to get in the practice of working with an auditor and getting your statements audited each year. So you need an audited opening balance sheet to go into a registration state. The federal law allows for a phase-in, so if you're new and launching and you want to explore that, then you talk with your attorney about that.
An audited opening balance sheet.
But it does take weeks and thousands of dollars, even though there's no activity and it's a deposit.
Net worth. That's what you're paying for. And I'm sorry the accountants have minimum rates and whatnot, but
Right.
it is so easy to do. They may not be able to get it done on April 15th, and people are very busy, but I always believe it is the right practice to have one out of the gate. I think trying to
Yes.
anything in arrears is always more costly.
Yep.
And I would rather just have, and as soon as you tell me you're not going to a registration state, I can guarantee you what your next call is going to be about. Guaranteed, 100%.
Yeah.
And it'll be an emergency.
And then you're going to be sitting there forever. Yeah.
I can't believe it. What? Registration state. Oh.
Yeah.
Right, so, but you gotta start, and talk about.
They're in there.
We're gonna get an accountant to do the audit, put it in, and then file and wait. So it's.
Yes. Agreed. Yes.
Quick question.
Can the legal team lead that call? There's nothing to prohibit that. I don't know what, you just need to be careful about what you're asking. I think if you frame it the way I did as a statement and then give somebody an opportunity to speak up and they don't, I think that's pretty powerful. Or I have some franchisors who do post-closing interviews. And once it's post-closing, you can ask all of those things. Now, maybe that opens up Pandora's box and you find out about all of these issues that are going on in your sales process. But you know that very early on, before somebody signs a lease and starts spending all this money or securing loans. So I do think there's good value there, and all of that would be admissible in court. And so if you have that interview even just immediately post-closing, that's worth considering. But there are other legal issues, so you want to make sure you navigate that delicately, maybe talk with your attorney about it before you do it.
It's going to save you a broker commission, right? What we like
Right.
these things about is they flushed out if it was a bad deal that I was paying, or you were paying a big commission on, because you could not do the deal and not pay the commission, right? You
That's right.
yourself by this disclosure. After the fact, you now have to call all the people who you paid a commission for the deal and ask them to give it back.
Right.
Put your hand up if you ever gave back a commission for somebody who bought that. No one's ever given back a commission. So it is really not that helpful.
Right.
It's just the way the laws now are for them.
Okay. Yes?
So kind of off of what you were saying, Lane, with like the pre-work and preparation, is it better just to knock out all the registration states at once so that you're prepared and ready to go, or is it more like case-by-case basis of when you need to, that's the time to
So
apply?
it depends. And so it depends on how much capitalization you have. Some clients, some of our franchisor clients are the most capitalized, meaning they have the most unencumbered equity at the date they launch. Except for the states that have experiential requirements, like if I have the most equity, that's my best chance of getting registered. Income recognition rules are predatory, meaning the $40,000 fee that you're collecting takes you 10 years to recognize, which it didn't before, which creates large pockets of liabilities in your statement, the more it's the blessed curse of success. So if you can only recognize, let's say, 10% of your initial fee in the first year, so if you have $40,000 fee, that's $4 grand, 36,000, where's it go? A liability, accrued liability, right? What does that do to your balance sheet? Right, so you could do, if you put $50,000 in a capitalizing company and do 2 deals, you'll be insolvent by the end of the time that's done. So if somebody tells me they've got to be in a registration state, then you've got to go in, I think, first.
So I think just to build on what the point Lane is making is that you have some registration states that pay attention to your financial statements. And if you submit an FDD that has weak financial statements, they're going to impose what's called a financial assurance requirement, which will require that you select one of the options they give you to satisfy that requirement. And most will require that you not touch the money until the franchisee opens, which nobody wants. So I think you need to come up with your plan, your sales plan, and with your sales team, and maybe there's a more targeted approach for growth. It really does depend on your system. Some grow close and slow, and some take a shot across the board. It really does depend on who the franchisor is, what type of support systems they have in place. I mean, if you're just on the East Coast and 2 of you, then does it make sense for you to be expanding in the West Coast? Another consideration is California and Washington are not friendly climates for franchisors, not just from a registration perspective, but they've got a host of other laws there that are not franchisor friendly. Issues with enforcement of post-term non-competes, liquidated damages. Washington will question whether or not provisions in your franchise agreement are reasonable. You have regulators asking you whether your contract provision is reasonable. I think that's a major overstep, but they use this broad language in the statute to enable them to do that. So not friendly environments. It should be a discussion with legal and sales and figure out where you need to land. Yes?
I was gonna say, it's minimum wage in terms of, I mean, I don't know what your item 19 looks like or how emerging franchisors use their item 19, hopefully to put their best foot forward, but if I have a store in Philly where the minimum wage is $8.75, or I have one in California where it's $22, that's not gonna look like the same business. It's certainly not, nothing you said about it on the East Coast is gonna be true about it in the West Coast. And I don't know why people come up, they've gotta be in California because they want the lifestyle, whatever it is, but it's the worst place to start if you're trying to demonstrate the quality of your business model.
Yeah.
Unless you have no employees. Then it's great. But with employees, it's not so good.
Right, and the statute's pretty aggressive, and if you mess up, there's all kinds of remedies available to franchisees, so you have to be very careful and aware. Yes?
So your beginning stages, as someone who's from Washington,
I'm sorry. It's beautiful. I'll be in Seattle on Thanksgiving, but go ahead.
do you think it's smarter to target like states that are local instead of Washington? Maybe go for Oregon or Idaho?
I mean, it really depends on your system. You don't want to give up business opportunities for growth. So what's your business? And if that's something that would really thrive in Washington, then don't discount it. Just be aware of what it means to go there and what you're giving up in your contract to go there. But in the surrounding areas, if they're not registration states and the environment is more friendly, then why wouldn't you consider that, right, if the business would work there? Right. Yes?
For annual updates, is there a way to file on January 1st and drop, and then add, whatever you need else, like audit and everything else later on?
No. If you don't have your audit, you cannot file your renewal. You'll have to file an amendment if you get approved, so it's not wise to do that. But you can file you can file early. Some states limit you with how early, or they'll treat it as an amendment instead of a renewal. So you can file early, but you can't do like a placeholder and then filling your audit when that comes, if it comes. Okay, yes?
So what if you realize that I'm a franchisor, and what if I realize somebody on my team said something that they shouldn't have, right? Because, I mean, I'd love to say that I say perfect things all the time, but this mouth sometimes, right? I'm like, no, I take it back. So let's say somebody has said something, would you kill the deal? What if the person still wouldn't buy?
It depends.
And then you're killing that consultant relationship if they came that way. Like, hey, we can't sell to your buyer because we said something stupid. So if you're in that situation, something said,
Wait, you found me a buyer in a place I wasn't wanting or qualified to do business.
no, I'm saying if somebody on our team, and I'm saying this, but you're like, you watch it go down and you're like, man, what were you thinking? And you get off the Zoom and you realize the mistake was made that should not have been made.
So it depends. What was the stupid statement? If it was a financial performance representation, well, then that's serious. If it was something else, then I'd want to know what else, and there's probably something you can do, record another one to correct whatever that statement was. But if it's a financial performance representation, those things are really difficult to cleanse, right? Because
My question, because it hasn't happened, but like eventually.
if it does happen and you become aware of it, then you should contact your attorney before you close on that deal, because
I wouldn't assume it's going to happen, and it happens in every realm. I think there are very competent people that choose to be well informed.
I mean, I hope so.
Is there any other franchisors who've come to a point in the process where they felt for a minute that the franchise prospect wasn't the right thing to do, and you walk from that deal to you close? You look like did you?
Where the prospect wasn't right, or?
Yeah.
That's not what I'm saying.
Yeah, you're talking about actual, like,
Listen, I got a great team, but as you grow.
it'll take you 2 years to break even. It'll take you 6 months to break even. It's like something simple like that, but that's a big problem.
What are you thinking,
Right.
right? And you're like, I'm not saying it's happened yet, but as we grow, we're emerging, right?
Mm-hmm.
So we're gonna have different people come in, and so I guess the question is, because yeah, we've dealt with that. We've turned a buyer away that was not a good fit. What do you do? Like,
It depends on where they are. I mean, obviously, you want to set the right expectations, right? You need to make sure that the prospect has the right expectations. And if something that was said, and usually it's in the FPR area, well, what was said, and can you fix the impression of what was said? And if it's in a non-registration state, then maybe you can have some discussions and acknowledgments made beforehand, but in the registration states, as we discussed, you can't get those anymore. So you would go in with liability exposure from day one. So
Pre-sale, there's generally some stuff to do, right? There's some things you can say that is not true. We're going to stop. You need to go do more validation with our franchisees on that issue to make sure that you're fully informed, right? And then come back to me. But I think post-sale, now you're at like offers of rescission and things that, especially in the registration state, are going to have huge consequence. But if I know about it ahead of time, we try to fix it by having acknowledgments that it's not, whoever presented it, it's not true or accurate.
but now in the registration states, you can't get those.
but I think that is her question. If you do find
Is that the question? Or person?
The reality is, look, you don't go into business if you think things are gonna be perfect every day. You shouldn't go into business then, because things aren't gonna be perfect every day. It's an unrealistic expectation.
They're not, it is.
I mean, I shouldn't go home then. But I mean, like, you go with your best effort to do your best thing, and you train your employees, and you hope that that like carries out. As you grow, it becomes harder.
Yeah.
Have employees ever had franchise sales compliance training? And I asked that, it's a rhetorical question.
They have. Mine does now, but we're growing. So I just added a new director.
You
And
can
I'm
never
gonna get it for him.
enough, right? I think the point is the caliber and quality of the people that you have, and then the training. My first earliest point of that,
Still can't
you
be
offer
perfect.
training.
Yeah, but I think your idea about validation in the state, I guess the point is you should always have strategy, right?
Mm-hmm.
Because that's what you want.
Yeah, it's risk and exposure.
Mitigation, yeah,
Yep.
exactly. That's kind of what
Yep.
I'm asking is like, if you find yourself in that situation, what are things? I would, yes, I'll call your attorney.
Right.
It's good to think about too.
That's right. And one big piece is making sure you're managing the expectations of that prospect. They're not expecting to perform in a certain way based on what was told to them. Okay, so in addition to annual updates, the law also requires that you update your document in the event of a material change. So if you issue your annual document and then 3 months later you get sued, what do? Well, that is a material change. A prospect's going to want to know about that. So you need to stop, amend your document, reflect the material change, reissue. That becomes complicated when you're in registration states because it may create an interruption in your sales process because you'll go dark in some states until you get approved on the amendment. So it's things that constitute a material change. Material is subjective, but there are some things that we know are material. A lawsuit would be one, depending on what the allegations are. If there are allegations of fraud or deceptive practices, then clearly it's going to go in your item 3. A loss of a certain percentage of franchisees. So if you have a significant number of franchisees close, well then that would be considered a material change. If you have an item 19, financial performance representation, you have a heightened duty. That means that you need to be aware of what's in item 19 and aware of what's going on in your system. Because if you present a picture in item 19, because it was based on last year, and then something happens and the performance of those locations changes materially, not for the better, right, for the worse, well then you need to pause, take a look at your item 19, probably amend it to reflect this updated financial performance information that's more recent, and then amend, reissue, file your amendment applications in the state. So item 19 is an important one to make sure that you're on top of, and that's one that I find is often overlooked. Franchisors aren't always thinking about that, and they just think you update it every year, but COVID was a perfect example of a material change. There was no change in the law during COVID. It just put a big giant flashlight on this requirement because franchisors, that hit at the worst time, right when everybody was filing their renewals, reflecting performance from 2019, and then they had all this disaster happen in 2020, and so it created a very difficult registration season for most franchise companies.
Question. Prior to litigation, if you've got mediation, would that fall underneath a material change?
No, which is probably a whole nother session, but you need to be very careful with how you craft your dispute resolution process because, when a franchisee consults with an attorney, the attorney's gonna throw everything at the wall, whether they really think there's substance behind some of those claims or not. And unfortunately, that creates ramifications for the people named in those complaints. So really important, you're entering into a business relationship. Everybody needs to understand that, and that if there's a problem, everybody should agree that you should make some attempt as business people to sit down and try to resolve it together first. And then if that doesn't work, well then take the next formal step and go to mediation. Mediation, nobody's making any decision there. It's where both parties get to express what their sides are on a particular issue, a dispute, and a mediator will try to work with you to come to a resolution. They don't make a determination of liability there, and so it's a great process. Everybody should have that in place because once a lawsuit is filed, it is a runaway train. And the incentives change and shift, so you definitely want to have that built in mediation absent litigation or arbitration filing would not trigger item 3.
Mediation is the single best tool in that document. I don't know if anybody's ever read it, no franchisee ever has, but there's a mediation provision in some of your stuff that is the most useful thing you'll have. It is binding, it is required. You cannot advance to litigation without exhausting the mediation process. It is a hassle. It requires them to come to you. It costs, I don't know, $10,000 or $20,000, and it lets people get in front of somebody and tell their story. And for many non-professional litigants, it is enough. I don't want to jinx ourselves, but we have had very good luck so far in resolving cases in mediation. There's a lot of incentive on both sides because the resolution does not need to be reported. We're all concerned about modeling behavior when we say, oh, some franchisees said, oh, and we gave them back $200,000. And I put that in here, the line is going to start to form out the door for people that want their $200,000 back. And so I'm much more reluctant to enter that kind of settlement as opposed to a mediation. They just go away. You get mutual releases, you get more money in, you can buy equipment back. You have a lot of latitude. And we see sometimes people settle these things in the most terrible way from a disclosure standpoint. Instead of maybe settling the negligence claim, there's things you can do that don't necessarily make it get into your document or minimize the magnitude. And you should be considerate of that. And you see some people, they bring it to us, like, why don't you show us this before you did it? We could have made this way easier and more palatable for you to describe going forward to your existing process. Because how long does it stay in once it's in there?
Well, it depends. So long as it's pending, it stays in. If you lose, it stays in for 10 years. If you settle the case and you give up any rights or you pay any consideration, it stays in for 10 years. And you have to disclose some of the terms of the settlement, even if it has a confidentiality clause. So it really is a different environment. Everybody is incentivized to resolve at mediation pre-filing. So it's a really important thing.
All you franchisors, you have to do when you go home, you're at franchise, just make sure you have it. And I only say that because, I don't know, if you could lower the 50%, it's many more than I would expect as a person, because they've been in places for education, all the fanfare about mediation. If you don't
You get some really great mediators. You know, they tell everybody, the lawyers will win if it proceeds to litigation, and you both probably won't win. So, or feel like you won at the end of the day. Financial performance representations. Oh, any questions on that? No? Yes?
A general question. A lot of my brokers like to sit in on that first call between the candidate and the brand for various reasons. I mean, collective question, better to not. I mean, that'll influence how they handle things going forward too. So, you know, I mean, you know my position, so I'm here trying to figure out the best way to navigate all this.
To have a broker sit in on the first meeting between well, there's nothing that precludes that. Legally, you can do it. Does it make sense to do it? I mean, I don't know. I guess it depends on how your people operate through the sales process and if there's something that they learn at that early stage that helps them. I'm sure in some instances it's
all the discussions, all the negotiations, the contract negotiations, you go to the franchisor. Your person shouldn't be saying, shouldn't be negotiating, shouldn't be opining on them, saying that's a good idea, I've seen that a lot. They should just be flies on the wall
Right, just be quiet and listen.
to know that it
Still,
all happens.
does that put us in a more,
I think if the purpose is to keep a shoulder behind it, like from a timing standpoint, I think that's a noble purpose.
Is this like a liability question that if the franchisor's person says something they shouldn't in that call and you were on it, and then the deal proceeds and it closes, do you have exposure? Probably. I mean, you didn't do it, but
whether we're quiet just because it was set up that call?
they typically sue everybody. So, yeah. You're probably going to be named. Yeah. Maybe get out of it, but, you know, that's going to cost a lot.
Determining residency or domicile. If they do it incorrectly, then the pendulum swings against the pendulum swings. But if they just are quiet and let a franchisor negotiate with a franchisee, but keep a shoulder behind it for timing purposes, it's fine.
Unless something inappropriate was said.
But usually if they said something, they furnished a piece of paper, they gave
No,
something.
not
to the
them,
next
this franchisor, saying something inappropriate.
Well, I think you want to know that, right? Because maybe then that says something about the franchisor you're working with, and maybe that's not a franchisor you want to be working with. Or maybe they don't know and they need to be educated So, I mean, it doesn't necessarily have to be nefarious, right? Maybe they just need to be educated. This isn't all obvious, right? If you're in any other sales line, I mean, typically you could say the things that you can't say in selling franchises. Fin-
Obvious. Rashida said that's the most, you have to train somebody if you want them to know something, just like anything else they do for you, right? It's not obvious and it's not instinctive what you can and can't say. Because people always say to me, they're like, Lane, but it's true. Well, true didn't matter. True wasn't even calculus. But that's what they think, because that's how your brain works.
Yes.
That's why all your new franchisors and anybody who's working with somebody new, they should have some kind of compliance training.
All right, financial performance representations. This is probably one of the most important areas. This is where you see all kinds of mess ups, and this is what yields the most liability exposure. Financial performance representations are defined really broadly. They include the obvious, which is, revenue, profit, net profit, but they also include things that aren't as obvious. Stating an expense as a percentage of gross. Communicating how long to break even, how many members you need to break even. There are things that you can say that would allow for a prospect to back into a number, and if that's what you're saying, that is prohibited. If you want to talk about performance, about financial information, then you need to have an item 19 disclosure. And then the question is whether or not you can, and we'll get to that in a second. So here's the very broad definition. This is the FTC's definition of a financial performance representation. I won't read that really long paragraph, but it includes a lot of things, right? The obvious and the not so obvious.
But anything you say to them about earnings or profits is probably bad and violative, right? That's, unless it's in your FDD.
Right.
In your FDD, which is why we encourage folks to put it in the item 19.
So, yes.
How do franchisors and brokers protect themselves from like the major FSOs just on the second call doing a financial performance, like plug in the numbers, Excel document, year 1, year 2, year 3? How do they do that?
We're going to get into the use of spreadsheets and practices, but if you have a contractual arrangement with an FSO that's doing that, you are responsible at the end of the day. The franchisee will sue you. They're your representative. So there's nothing you can do as it relates to the prospect to cleanse yourself from that activity.
And you described a pretty fast and loose FSO. I know many that are more.
Yeah, I just said some of them, like, because I play in that space, so I know the same candidate, talking to the same candidates, and they're like, can you send me your performa, your Excel document that I can plug into? So I just want to make sure the emerging brands here know that they can be held liable for that, and that they should go through the sales process for whichever.
That's right. That's a very good point. You are responsible, franchisors, for what your brokers say in the sales process. You may have a contract that says they're responsible if they say something wrong, but as it relates to the franchisee, you are responsible. That contract does not save you from that liability exposure. You own what they say, whether it's an FSO or a consultant or a lead generation expert or a broker. There are all kinds of terms used out there. They're your representatives. So if they say something wrong, you own it. There are ways, if you don't have a financial performance representation, the questions come up, what can you do? If you have franchisees, well, they're free to talk about their performance with prospects. So you can refer prospects to your existing franchisees, say, you have a list of all of my franchisees. It's an exhibit to the FDD. You have all of their telephone numbers. I encourage you to reach out to as many as possible. Ask them these questions. They can share their performance information with you. And that's a good thing to do to get it directly from the franchisees. Yes?
If you set up an appointment with that franchisee, is that allowed?
Steering. And right. Yes. So that's tricky. You don't want to steer. So you don't want to have your one rock star franchisee that you refer every prospect to. Call so-and-so for validation. and there's just one person or a few people on that list and they're the same people every time, but you've got other franchisees out there that you know would say something different. That's not a wise practice. You can say, you should say, I encourage you to contact as many franchisees as you can. You have all of their information. I do know that these people will take your call. Not everybody will take your call. So here's a list, but again, call as many as you can. You want to get a nice wide range of opinions and perspectives so that you come in with the right expectations.
But let's ask how the question really gets asked. In a small system with a few franchisees, the question gets asked, I can't possibly give 200 leads my one franchisee's number. They're going to call and we won't get anything done. So I have to help organize a thing where the franchisee can talk to these people in groups. Okay, don't have them talk about financials. They can talk about how much they love the business, how much they love sewing machines, how much they love whatever else about it. But they can't put up by you, start rattling off the numbers. Not that they're not franchisees, but they become your agent. So the answer is I can always set up the call, as long as I'm not setting it up to convey illegal item 19 information.
Well-
That's what the one reported case says. Franchisor set it up, franchisor wrote invites, franchisor wrote thank yous, and the existing franchisee spilled the beans, and that was a total loss for the franchisor. So that's how the hard way, that's how the question, the law doesn't care how inconvenient it is for your sales process or your single franchisee. There's no, but if it's inconvenient, you don't have to do it, right? That law doesn't read that way. You have to do it same way both ways.
Right, so if you give the contact information and the call happens separately from your involvement, so long as you're not steering just to that person and those issues aren't going on, that's okay. But if you have a situation where you've set up a Zoom meeting, for example, or whatever platform's more popular, and you're on it too, if the franchisor is on little bubble one, and then you've got your franchisee and you've got your prospects on the bottom, and then the prospects ask the franchisee questions about performance, well, you're on it. So that's not an appropriate environment for that question. So how do you get ahead of that? If you're gonna have those validation calls, which a lot of systems do, you need to make sure that your franchisees who are participating know that those questions are off limits. So they will be asked, it's just natural for a prospect to ask it. So the franchisee should be educated to say that I can't answer that for you in this call, but I'll give you my number and you can contact me separately and I'm happy to share with you my financial information.
Joanne, what about ride-alongs? A lot of
Ride-alongs.
full-service businesses invite prospects to come ride along with an existing franchisee. Problematic? I don't know. Where are they going? Are they going, they're only two big commercial jobs, they're only that day where they're taking people out, or is it just a regular day in the life? Are they seeing representative work, or is this a whole subterfuge to walk by the three big jobs they give you, right? So it matters. I would say that I just want to, this item 19, people have asked, so what is the purpose, right? And some people tell me it's to put the franchisor in the most favorable light based on its existing financial performance. That's kind of what I thought it was. But as the world's focused to more responsible franchising, people have asked that question. And I think that part of the item 19 in a world of responsible franchising is to manage expectations. In addition to showing your best numbers from your best thing in the world. You don't want people to be dissatisfied. Joanne pointed out to a lot of disgruntled people now. I call that the early quitter pile. They barely got the business open. Somebody else balked and they're like immediately jumped on the train that says, I'm going to sue everybody, then I'm going to persevere in a business that I just bought. No, right? So and they do so most likely when they're disappointed with the financial performance. Of course it's in month 2. I would have guaranteed that it would be poor in month 2, but that's when they're drawing the measuring stick. But I think that there is some overlay on item 19s that focus on trying to build out reasonable expectations for people who are going to do the best and people who are going to do less than best.
You really need to be careful with how your item 19 is drafted. I mean, in order to have one to begin with, you need to have a reasonable basis. What does that mean? We can disagree over what a reasonable basis is, and you need to have the substantiating documentation to back up what it is that you're presenting. And so you don't have a reasonable basis to just show your best. And the interpretive answers to the rule don't allow for you to do that. There are certain metrics, there are specific things that you need to include in your item 19 if you're discussing performance. And the footnotes are really important. Giving transparency is really important. Transparency is your friend in financial performance representations. Without it, you're just whether the law specifically says whether you need that specific detail is one issue. But you want to be as transparent as possible so that you can defend against somebody that claims that they read it a different way. And often the story is crafted by the attorneys. They never thought that they were coming in and expecting to do what this location historically did, but that's the picture they will paint. So you need to be very careful and work closely with your attorney to determine whether you have a reasonable basis. You'll be advised to keep and retain your substantiating data, because if a franchise prospect asks for it, you have to give it, and you need to have it to substantiate it in the future if it gets called into question. Was there a question? Yes, a few. Okay. I'll go here first. Yeah, I mean, this is really one of the number one issues that comes up in demand notices. And I just took some.
It's everything from reasonable basis. Like, if it happened, you think it's a reasonable basis. But it really, your reasonable basis to say that this business is substantially similar means it has to be substantially, nearly identical. And people always say, well, if this is what this one does. Like, they're not identical by the way you're trying, how long it takes you to explain it to me. Right? If they're identical, I pretty much get it the second you tell me. But tell me why everyone's different. I'm having trouble seeing why they're identical and why they're substantially similar. So, like, it depends on, and some people have only a certain permutation or footprint that they're franchising, and then it becomes a little bit easier. But.
Yeah, I mean, in the demand notices, that's like always, you're always going to find a paragraph that says so-and-so represented how much my client could make or expect to make in this business, and they had, or maybe they'll attack the item 19 that they didn't have a reasonable basis, and the client was fraudulently induced to enter into the relationship. So you need to be very, very careful with your item 19, especially in light of you can no longer use the questionnaires or the acknowledgments in your franchise agreement to help insulate yourself from liability exposure post-closing. We had a couple other questions. I didn't want to skip over them. Yes?
With like an effort of trying to be as clear as possible, is there like a line that you can cross where you're putting too much into your item 19? I know there's stuff out there where you can really get as granular as you want, but like, I've seen people put like full P&Ls in there almost, and then you have people who are only doing top line sales. Like, is there a happy medium, or should you just?
It really does depend on your system and what the information is and how that relates to what your franchise businesses are performing, and whether that all ties into that reasonable basis analysis. So it's good to be detailed. We've got lots of clients that have a lot of detail. I think detail is helpful if you have enough of it and it's representative, right?
What we mentioned, so the more detail, I think, the better. Often that's driven by what your competitors are doing. It's a competitive set that describes all this other stuff, and you don't. Giving people top-line information is like giving them something because you have to, but it tells them nothing. Right? Rob, do you care that much about top line without profitability? Rob's a big Dunkin' franchisee, but I think we've had this conversation a million times. Like, it's top line tells you nothing. So people put it in there.
But sometimes that's all you can do, depending on if you're in an early stage growth. Sometimes that's all you can do and all you should do, because maybe the data's messy. Yes?
Regarding steering
actually running their business the way that they're supposed to? Would that be a gray area? Or would that
I don't know that I do it in the FDD because maybe the people change, and I don't know that you need to communicate who your advisory council members are to the world, right? So maybe you want to keep that out of the FDD, but I don't see anything wrong if that's the way your advisory council works with sharing who's on it, and they could call them. But again, it also needs to be couched with call as many as you can. You've got all of their information here.
If you're looking for, if you're trying to sort of steer, but legally, the advisory council, it's a very true fact that they're more engaged and that they can provide information what it is to be in a leadership role here, right? And that's very.
But how did they get on it? Did you cherry pick them? Are they, what were you going to say?
It's different than operating. Like I'm one of the leaders of my advisory council. My business is operating, but I'm here. So I don't know how useful that is.
Is it semi-absentee? No, it's absentee. It's not absentee. Or semi.
So, but I was going to suggest that there may be other ways to steer legally, right? So if I'm an educator and I want to know who in your system is also an educator, or who's a husband and wife team, or who speaks French, right? These are French you're not going to have necessarily spelled out in Item 19 itself. But you could either create a supplemental that would be just for those people, or I think people would say these are the 5 people that own these things. So you can have people and try to flesh out the degrees of kinship with your prospects, right? And people that they'll get along. We try to do it all the time with personality, right? But so this is in their other demographic attributes. So I think that that's a perfectly great way that people try to put people with like-minded folks.
Yes.
Hey, on the kind of the opposite side, as far as trying to get a clear picture, you're speaking into your item 19, and they were saying, oh, so I can do this, that, and the other thing for revenue. Did you ever say, hey, that's a little unrealistic?
So that's a great question, and you're like reading my mind because that was the next thing I was going to talk about. What is your item 19 and what isn't it? Your item 19 is historical. If you have a projection in there, then please come see me. Nobody does projections. It's historical. So what does that mean? It is historical. It's what a unit or units did do during the certain stated period of time, period. It's not a representation of what they will do in the future. It is not a representation of what the franchise prospect can expect to do. It is a representation of what units achieved in the past, period. It's information. They have to do their own due diligence and their homework and prepare their own business plan. That's information that they'll consider in doing it, but it is not a representation of what they can expect to do. And it's very important that your sales team understands that distinction, because as you get into the natural questions that come up and the use of spreadsheets, which many people do, if they're not getting their words right, they're creating liability exposure for you. And often that's in maybe a PowerPoint or it's in a Zoom presentation. You need to be very careful with your words. It's easy, it's historical, period. That's it. It's not and so as long as your people get that, then they'll probably get in the habit of talking about it in the right way. Use of spreadsheets. You want to help, to someone's point over here. You want to do the right thing and you want to help. And I think, unfortunately, the law's gotten so constricted, you really can't help without creating liability exposure for yourself. How unfortunate is that? But that's the world we live in, right? You can provide blank pro formas, but really what good is that? But that's all you can do. You can provide a blank pro forma. You cannot provide a pro forma that has any data populated in it. Because again, even with your item 7, there's temptation to complete some of the lines, right? Maybe with your royalty rate, or if there are flat rates, you can put that information in. But item 7, what is that and what isn't that? That's another one to get your words right with. Item 7 is an estimated initial investment. It is not what you will incur to open, it's what we estimate today. Your experience might be different. It's an estimate. So you don't want to give the prospect the idea that this is what it's going to be, and let's fill in all these lines, and let's create your business plan and your pro forma, and we're going to just fill in all these blanks. So you take item 7, you take item 6, you take item 19, and populate all this. Don't do that. Don't do that. Get your words right. They'll use them naturally as tools, right? And that's really what they get, I would think, in the sales process. But that is not the picture that will be painted after they sign and they're disgruntled, if that happens, which it happens. You're always going to get problem.
Can you have the expense categories listed down the left side as long as you have no numbers filled in?
Categories are fine. Numbers are not. And you can't build in formulas. Like labor should be X percentage of gross. You can't pre-populate that so that then when they plug in their estimate on their revenue then or their labor, then they know what the revenue, you can't allow them to back into numbers. Yes? Hi. How are you? It's so good to see you in years. So nice to see you. Okay, I'm sorry. I would hug you, but there are all these people. So go ahead. Okay.
What if you say like a target, like a range of what industry would expect?
A target, no, don't do that.
As in like what industry standards would say anybody?
I wouldn't do that. Tricky. Because then you're implying that that's what you do, that what your system does, or just shy away from it. You can tell them that there are plenty of industry statistics available out there. When you're doing your homework, you can investigate all of that for your due diligence. And maybe that's helpful information for you. It's not about our system, but that's about the industry in general, and that's part of your due diligence, part of your homework. Yes. Yes.
Can you just say something about brands who don't want to have an item 19 or emerging brands who think they're too young to have an item 19 and the headaches that causes?
There are brands that don't have item 19 disclosures, and that just means that maybe they have franchisees that are able to communicate. It's difficult to sell without having any performance.
There's no barometer against which to measure the oral representations you hear while you're in the process. If you hear things that are wildly inconsistent with the item 19, like your printed FDD has the right numbers in it, it's what brings everybody back to the table. And it's far more reasonable to rely on a printed, registered, a document that has an effect versus some jibber-jabber you heard in the back seat from some grind you took to someone. So it is incredibly difficult if you have nothing. Because if you have nothing, no item 19, anything you say. My kid goes to UVN. That's $78,000. I can look it up tomorrow. My kid, you'll be able to have a Porsche. A Porsche 911 is $104,003, right? Easily calculatable, and it's exactly the same as promising that amount of money. So it's like super important that you realize that without one, you're totally undervalued, I think.
And it's information, right? It may be that the system is brand new and young, and they have just one location that's been in operation. And that's data, and so long as there's nothing that's materially different in the way that it's operated, it's helpful to have that data, right? It's part of due diligence. If it was a franchisee, they'd be able to call and get it. So I think that there's tension there, because some will argue that we didn't have a reasonable basis because it was just one. It was like, well, this is what this did do. It's historical. It's a similar business. And it's just information. It's not a representation of what this prospective franchisee will do. It's information. You need to have footnotes. You need to have transparency.
There's people that say, hey, I charge a flat fee. I don't need to collect it. I don't have no access to it. Don't have P&Ls, don't have a POS.
Yeah, okay. Then if you don't have access to the data, then you can't have an item 19 that's meaningful. So there are those systems, but
If that's your case, you should figure out a way to do some kind of benchmarking study so you're not the only person who has no idea what's going on in your company and how your units are performing.
yes. Yeah, all the way in the back first, and then I got you.
So I think it's important to like some of the lawsuits that have come out over the last years is for claims of semi-absentee or part-time ownership or absentee ownership. If your item 19 is built on 80% of your network being full-time in the business, but the sales process is part-time or you can hire a manager, that's where a lot of lawsuits have come. So how do you protect yourself from that in the sales process?
I think in today's world,
Part-time and 919 is full-time, like how do you make sure that you're protected?
if you have the data and you have owner-operator and under an absentee, or so I wouldn't even use those words. I don't have a problem with those words legally. I think semi-absentee, if you're an owner-operator, it's 40 plus hours a week, 50, 60 plus hours a week. If you're a semi-absentee, it will be fewer, but you're going to need to have a manager that's going to be doing the full-time right? I don't really have an issue with it, but it's created so much buzz in the litigation world right now, I wouldn't be using those terms. Franchisee lawyers are just seizing on them. I think you can defend them because if any business could possibly be a semi-absentee, if you find a rock star manager to run it, and you keep your job, and that person you pay to send to training, and you pay them a healthy salary, and you're not pulling a lot out of the business, recognizing you want to be semi-absentee, and you're going to put the time in to wait to harvest those results, right? But
It's a terrible way to represent the effort that you want someone to put in their
that's the other issue.
absentee in a million years, maybe in year 3, maybe in the second summer, you can take 2 weeks off. I came across one of the doctor's practice operated by civilians, whereas the civilian can't do anything. It could be like the receptionist, but that's it. That's like the closest thing, but I think that it's unbelievable that you will not have to put serious effort in the beginning, and I think it's entirely
They won't, it will fail, and then they will sue you.
suggest that it's that easy. If it was that easy, we'd be doing it ourselves. That's the difference between franchising and doing nothing.
Yes.
Back to performance, how do you disclaim or warn a prospect not to email you or copy?
Oh, that's a wonderful question. You need to advise the prospect before you send them a spreadsheet if you're using them and they're blank and you don't have any of the pre-populated formulas in there. You need to tell them that, unfortunately, the law doesn't allow for you to comment on or even review their completed spreadsheets, which seems crazy because what if they're completely out of this universe? You can't ask for to look at it because it's implicit that you're either approving it and then you're talking about what your performance is, and so you can't do it. So the best way to get ahead of it is to say it immediately before you give it, because otherwise they're just going to send it back. And you can even say, if in the delivery of the spreadsheet, a warning, do not email me a completed spreadsheet. We will not review it. Your email will be immediately trashed, deleted. You can't review or comment on it.
So I would not review or copy. So you're going to get one, even if you put the 10 emails out. Nobody reads it, right? You're going to get one that says, hey, how's this look? I did it exactly like the end of 19, just like you told me, right? The answer is, I have no idea. And I would say something fun. I have no idea whether you're going to be the most diligent person in the unit. We don't know each other, right? If you're going to hire your dumbest relatives, you're going to quit your job that you have now, whether you're going to offer good customer service. We don't know each other. But I can tell you how our substantially similar businesses are. And I shut that up. But if you get one, if the last part of the daisy chain of the emails back and forth can't be them asking you, you have to close it out. Unfortunately, I'm not capable of reviewing this for you and giving you this information back. Now, just to Joanne's point earlier, and I would tell you most people take a peek and then look at, oh my God, it's wildly unhappened. It never happened, right? Triple what our people do. So what am I going to say you do that? Re-education, right? Brainwashing and re-education. You got to go back out and do diligence in that thing. I don't want people to come in with I'd rather not sell them than them come in with expectations that are 300% of what they'll actually do. So without even telling them that's why I'm doing it, I'm going to try to get them some grounding from franchisees, hopefully that have some, that can give them better information. That's all that's fine.
One other area that you need to pay careful attention to that I find is often overlooked, if you are working with an outside organization, whether it's a broker or an FSO, they're going to interview the franchisor and find out about the system and performance, and that's not an FPR. If you're sharing performance information to educate on your system and what your businesses do, well, that's not an FPR. But what are they going to do with that information? And do they understand what they can't do with that information? Not necessarily nefarious. They'll put together a PowerPoint presentation. Well, let's talk about the evolution of the company and what the founder business and how the founder business grew from year over year over year. But that's not in item 19. That's an unauthorized financial performance representation. And it's memorialized in a PowerPoint, fully discoverable in Discovery, and that would be something that would be used to frame an unauthorized FPR. Yes?
During this due diligence phase of converting them from lead to candidate and ultimately signing a franchise agreement, you can give them a blank pro forma. You can't comment on what they filled in. You sign them to a franchise agreement. The pro forma is based on an assumption of a general premise of what this business opportunity could look like for me as a prospect. You don't have a site picked out yet. Now you're signed. You are, I guess, technically a franchisee because you signed the franchise agreement.
because you want to help and do the right thing, and you should be able to do that, but it comes with different worries. It's not pre-sale worries, it's not FPR worries, it's different concerns. It depends on the context, and it depends on what you're doing and what you're saying, but that could create other concerns. The law doesn't prohibit you from helping at that stage. Once they've signed, they are franchisees. You may review their business plans and their projections, and you may have discussions about that. But you need to be careful with the why. Why are you having it? What is the purpose? And just tread carefully there, because there could be other concerns. All right, we've got some examples of other unauthorized FPRs. There's Suits and Harvey, so handsome Harvey at the bottom there. Just some examples. Steering, we were going to cover this, but you guys have great questions, so we've already covered it. Yep, we've covered that. Qualification. So this is different. This is outside of really FPRs. Responsible franchising, picking the right people, allowing the right people into your system is so critical now, especially in this environment where people are so litigious. You need to be very careful with who you allow into your system. Make sure that you're educating them on your brand, managing their expectations as they should be, making sure that if you're selling them multiple units, development deals, that they have the capital to be able to execute. We find that there are more often problems if somebody, and they have a contractual right to tie up a large territory so that they can prevent competitors from coming in or other franchisees. There are good reasons why someone would want to make that decision, even if they don't ultimately execute in the entire territory. It's a business decision. But unfortunately, if you're too aggressive with the multi-unit sales and the people don't actually deliver post-signing, they're going to be disgruntled, and it just creates a bigger damage pile, so be careful.
Sometimes you have a really great single-unit franchisee that you sold 3 to, and they never qualified to build 3, they barely qualified to build 1, and now they don't have the working capital to really get the 1 unit up and running, because somebody convinced somebody that that the world was going to all, on the back of the new business, create these ability to exercise these opportunities, which are often a year or 2 later. They're not 10 years later. We actually might have a chance of making profit from your existing business. You look at those schedules; they're short, right? And they're intended to take that territory back. But it's the quality issue, responsible franchising, the issue of how much cash somebody needs, whether they're good for 1, 2, or 3, how you size up a candidate, or how you size up a franchisor in terms of their ability to support somebody who has a 3-pack or a 10-pack or a 20-pack. Goes both ways. What's the largest franchisee is Greg Flynn. He has thousands of units. I don't think there's a deal you could offer him that I would think is somehow unreasonable because of his skill and expertise in operating franchises. But there are certainly, and I don't care how sophisticated the franchisor is, because he's very sophisticated. But the other way around, where you have an unsophisticated franchisor and an unsophisticated franchisee who has no experience supporting multi-unit or getting people open, is just a recipe for disaster. It's a great thing to come up afterwards. It's like this semi-absentee. Like Elijah's going to do all the work, and you're going to come home, and it's going to all be, it's all going to be great. It's never going to be. Let me tell you what makes successful businesses: hard work. And there's no substitute. I was reading a quote that Bob Rosenberg's favorite quote that he has in his refrigerator for 20 years is that, right? Nothing takes the place of perseverance, not knowledge, not intelligence, it is not quitting and just staying at it and doing it. But it's hard to convince yourself that way some days.
And people nowadays want instant gratification, so it's hard to find them. Yes?
So we're seeing a lot of interest in multi-unit, right, across the board, on all days. What's your thoughts about franchisors offering training for multi-unit to help kind of downplay the risk of someone coming in and then they say, well, I was never really trained on what was all involved in multi-unit, blah, blah, blah. Tell me what your thoughts are.
Training is really important if you're offering multi-unit opportunities, then having a program that's designed to best position those developers for success would be wise.
Should it be in the FDD, like under the training section, like a separate thing for multi-unit?
Well, item 11 requires that you disclose your training program. So if it's part of your training program, you'd have to disclose it, but then you have to provide it.
It's a great idea to have multi-unit training and have at least a couple chapters for somebody who bought more than 1.
So I'm not aware of the problems, legal problems that stemmed from using them in the past.
It was, we had heard some issues with discrimination,
There you go, whole nother pot of worry, yes. Probably don't do it.
Personality tests were an interesting way to try.
I'm sure the questions, you need to be really careful with what kinds of questions you're including in there, yeah.
But I think you're looking for places for alignment, right? You're trying to identify personality traits of your successful operators and then try to recruit to those personality traits. I have no problem. That actually sounds intelligent, right? That's just profiling and targeting your market. And I think a good franchisor would definitely be doing that.
Yes,
I have a question. I've been talking to a newer franchisor who is clearly steering. And two questions for you. One, I noticed in their item 19, they didn't list the franchisee's name. They listed their franchise company as a way of making it more difficult for the prospect. First of all, are they allowed to put the franchisee's corporation name and not the franchisee's name in the item 19?
well, the franchisee is an entity, and the entity is the franchisee. You have a telephone number. So that is the franchisee in the item 20, in the franchisee exhibit list. Yeah.
I've always seen the franchisee name and their company. In this case, they're just showing their company name.
And that's the franchisee. I don't see anything wrong with that. Most do also identify an individual just because they're going to call and want to ask for somebody. I understand. Yeah, I don't think that there's anything legally wrong with that. If the franchisee is a legal entity, then you may list the legal entity franchisee.
And then the other thing is, what's the recourse for a franchisee if they have been steered? Like, how do you prove I've been steered? Like, what recourse do they have? Because it's not like they.
Well, I think that on the franchisee side, there should be another session for prospective franchisees with franchisee lawyers educating. I think they need to do a better job of working with the prospective franchisees and explaining that they have all of the telephone numbers. You might be steered, but you have everybody's phone number. Call other people. There's nothing to prevent you from doing that. So recourse, I wouldn't invest in the system if you feel uncomfortable with what's happened, but you've got the information. You have the ability to contact other people. Do it, right? I don't know if I answered your question.
Yes, good, thank you.
Okay. Yes?
If the officer or franchisor owns one of the franchise, can he talk to other candidates or not?
An officer of the franchisor who's disclosed in item 2 is also a franchisee. Can that franchisee discuss performance? Best practice, I would advise not to, because they're an item 2 person, they're a representative of the franchisor, it's clouding the independence there. I would advise.
Item 19, if there's only
Right.
one store, guess whose it'll be?
Right. Yes.
What if the prospect is buying an actual corporate store that's open and they're not an actual franchisee, they're new to the system?
Corporate store that's open, prospect wants to buy it, you can definitely share the financials for the location that's for sale.
Don't let that prospect live 3,000 miles away, because that'll be like the easiest way to figure out they really weren't a prospect for it. They should be.
It has to be a bona fide interest in acquiring the business.
Everybody's going to always test your good faith.
Yeah.
If you do something, you do the same. Everybody the same person every single time. In hindsight, well, the facts tell themselves, right? Somebody gave the earnings information 625 times to the last 625 prospects, right? Like, you can't undo that once it's already occurred. But it's how you execute. If you are doing drive-bys on Smack like that, you could put people in vans with people as long as it's reasonable and it's random. It shouldn't be Lane Fisher spends every day, every week driving prospects around. It should be, once you give different people a chance on a rotation or those kind of things, and the job should be normal. It's the good faith you exercise in providing that information.
Yes.
Can you request the franchise candidate only spends a certain amount of time with your franchisees, so they're not wasting your franchisee's time?
You can request that. You can say, just be respectful of their time. They're running a business. Whether or not they do, I mean, you can't control that, but you can say something like that. All right, if there's any other questions? If there's a problem and you discover the problem, what do you do? Well, if it's not an FPR issue and maybe you need to amend your document, potentially amending, redisclosing, and waiting could correct the issue. If it's a financial performance representation issue, it may be a scenario where you just need to walk away from the deal just because you just can't insulate yourself from liability exposure in those instances. You could confirm non-reliance on whatever the mistaken issue was pre-signing, and that might minimize liability exposure. But I've had instances where there were some issues that took place in the sales process, an offer of rescission made post-closing, a rejection of that offer of rescission. That means, hey, you can get out of this if you want. I'll give you your money back. You have 14 days, let me know. They decided, no, I'm gonna stay on, and I'm gonna buy another one. And now I'm not happy. And now I hire a lawyer. And now I'm suing you, even though I rejected the rescission. And that case went on for a long time. Yeah, so it's really difficult. Be careful with who you let in your system.
The main thing is not to sweep it under the rug, that if something happens, and things happen every day, and certainly no one's hoping it happens, but there are such financial ramifications. I was telling somebody that 30 years ago, we sold one packs for, $20,000, $25,000. If you had to refund somebody, Steve's my age, but you gave them the money back, and that was that. But in the world of brokers and $250,000 fees and multiple people in them, you don't have the luxury to give it back. So you have to make the right decision from the front end.
That's right. That's right. So if there are mistakes, what could happen? You can get sued. There are damages that the franchisee could seek to recover from you. Rescission is another remedy. That means that some statutes allow for a franchisee to get out of the contract and to get all of their money back. Rescission damage analysis gets a little bit tricky, but rescission is a remedy. They get out of the contract. If they're in California or even in Washington, some other areas, they can run a competitive business still. Attorney's fees, which can be insane. Trust me. Negative FDD disclosures, item 3. Litigation is such a drain. It is a drain on your time, on your energy, on where you should be focusing your efforts, and on your pocketbook.
There's also insurance people should investigate that has come up with, that it's franchisor perils, or sometimes it's referred to D&O, that resident officer insurance. Some of those things are really helpful to have, especially if the other side doesn't know you have it, or you have some partial person covering some of the fees and or even the ultimate recovery. And I guess I would say, point out that what's different now is that insurance companies seem to get in at the earliest possible stages. So it used to be that when you got sued, the worst thing you had insurance to avoid, then it would kick in coverage. But I've at least seen now quite happily that insurance companies and their adjusters are turning up at mediations and things that are not disclosable, and recognizing that they're looking down the barrel of all these litigation expenses and time and cost and being somewhat contributory.
Yes.
Lane, does off-the-shelf errors and omissions insurance cover franchise sales activities? Do they need to work with their broker to make sure that there's not an
You
exclusive?
have to read it. In fact, whatever it's called, even if it says franchisor protection, it's all very specific coverages with very specific notice provisions that matter. Like if you have a claim lingering, what the definition of a claim in your policy is a huge thing, and it's a trigger that gets them added in if you don't tell them about it. Right?
And we're talking about responsible franchising. This is part of being responsible. You're all sitting here and you've endured this with me, with these 2 lawyers for all this time. That's part of it. Insurance is another part of it. Having appropriate insurance coverage, because claims may arise, and that's responsible to have insurance coverage. It protects the rest of your system so that it's not such a significant financial hit for you if something does come up. So I just think that that's another piece of, so long as it's not prohibitively expensive and not everything is carved out, it's an important piece.
And I'll tell you where I found more coverage than anywhere else, because everybody, when they write all the things that you did, includes negligence. You did it intentionally or negligently. Negligence almost always is covered. Almost all people have a coverage or policy on negligence, and people don't realize that would cover that item. So I mean, it is you have to comb these things, and they're hard to read in a pain in the neck. And maybe you're a good broker. I think there's a set of good coverages, but I'd rather have some than none.
There's civil and criminal fines that could be assessed for violations of the law in the regulated states. They allow for jail time, some of those statutes. I think it's happened. Pretty egregious behavior.
We went about to go, I think, the jail sentence. But it's I mean, you ignore them on the first round. That's why I said there's a difference between like the person you're trying to get your FDD registered with and the person who's demanding documents from you and is giving you a subpoena or instituting an investigation, which is a very serious matter under one of these state statutes, especially when we're doing personal liability. You heard me.
Personal liability is the next
Don't
one.
hide behind the corporate veil. If you
Right.
did it, you're getting soft for it in California and in Illinois, right? So it's really important that you know.
Yeah, you can't hide behind the employer. If you're the one that made the statement about the earnings, you're going to get sued and you can't wiggle out of it. Government enforcement, you can have investigative actions. If you do have that happen and they'll work with you to reach a resolution, there usually is a fine, depending on what the egregious behavior is, will dictate how expensive that fine is. But once that happens, there typically, as part of that resolution, is a provision in that agreement with the government agency that says that you promise that you'll comply with the law going forward. That's considered injunctive language. And so what happens with that is you wind up having to disclose that in your FDD in item 3, and it never comes out. I had a franchisor with a state investigation. In the beginning stages, they messed up. They paid their fine. They went forward. 10 years later, we removed the disclosure, submitted to Maryland. Examiner said, "Why did you remove that?" "Because it's been more than 10 years. Put it back in. There's the injunctive language in there." So that means it never comes out? Never comes out. So you have to be careful. And work with counsel, because maybe counsel can help get the language right so that that doesn't happen. And private actions we covered. So that covers the compliance piece. Now we get to talk about the exciting new regulations that are going to be enacted. So more things to work.
So this is it's a big deal. It was well, we've been talking about it like it's a really big deal. Now it looks like that this law that California needs to build an infrastructure to be able to take these kind of registrations. And the infrastructure costs money, and California has none. So then they're going to build this infrastructure in 2025, and it looks like they now kick the can on this compliance date to 2026. So, and it also looks like where we're thinking like how much how much transparency would be brought into the franchisee, broker, I represent you, but into that, and how people get paid and who they represent. And I think that where it is now is sort of a one-sheeter with check the box in terms of ranges of whether you share in commissions or you share in royalties or you share in some other stock ownership or something. But a one-sheeter is less terrorizing than a long-page document. There will not be a review, there'll be a fine, a fee paid when it's filed, and a renewal. They talk nothing about what the remedies are, like who gets socked if you didn't do it, you didn't pay. If you didn't pay, do you owe $87 the payment, or do you owe franchisee rescission or those kind of things? That does not look any of those hard through. But most significantly, it's not going to come through until 2026. But back to my conversation when we started on responsible franchising education, and having an understanding or at least know what the measuring sticks are on some of these very difficult decisions when you're resolving conflicting interests and making these awards every day. We're going to try to identify people who know about it, care about it, who will present the data without being judgmental, but trying to at least put the playing pieces on the field. We're going to do that at a couple sessions here, the franchise development session. We're going to do that at this session John Tez is running for resolving competing interests at 4 o'clock on Friday. Sorry, Thursday, tomorrow. I'll lose my days. And I'm trying to choose the right people. We're not trying to have a fist fight or any kind of argument up there. We're just trying to flesh out what the issues are and what matters. How do you evaluate a franchisee? I Googled that forever. I mean, I'm sure everyone has their own way they do it, but there is no like standard criteria to say this. Okay, now this is good for a 2-pack. Like it doesn't. It's all qualitative, and there's no one right answer. And it's going to be different for every single brand. But it's so. But I think we need to be engaging in that discussion. I don't know if everybody saw this, so we're gonna in this franchise education vein, we're gonna keep track of you taking certain classes, educational sessions here, not because they're required now, because they're not yet, but we believe they will be, and we think this is a good sort of way to get organized, to get started. We're gonna come at you for annual, not requirements, but we're gonna hope you come because you enjoy it, that it's not that unpleasant talking about the FTC rule and other things, and we're trying to flush out the tough examples and the hard questions and what we hear from a whole bunch of people. So if you scan this, it will put you right into a registration sheet that will tell us that you were here, and we will keep that. We'll also have a different barcode for the one at the franchise development Springboard Youth session, and we'll have a different one at John Tez's session. We love people to scan all three of them. We love people to show that this group is a group that is not unscrupulous and uneducated like the regulatory. You read the background of why we have these regulations. It calls the broker community the worst people on the planet. And I'm not sure it's earned. It certainly shouldn't be earned among people in this community who take this very seriously. So we're going to try to put content in front of you. We hope that it will be of great interest to you. We will try to make it interesting and presented by all the right people. But we'll ask you to come to it and recommend that your people come to it. And know that you watched your new sales lady or salesman through somebody's compliance course. And maybe even if you have an internal one, because everybody tells me they have an internal one and how great it was, it is, but then you see they still are involved in activity, which would suggest it's not perfect. So I'm suggesting that people add on this other type of training to the training that they're already offering and already doing a great job on, because it can't hurt, and it also shows you're not just learning what you train people in, but you're also putting them in what the world thinks are best practices. And most people would never know, unless you see us, and we see 40 franchise owners doing stupid things. We hear stories every day. Like, we have context for it. We can put color on it. And we'll try to make it funny, but it's still, as long as it's not you, it's funny. It's not, when it is you, it's definitely not funny. But it's important to learn. We call it, Rocco says, you can't live long enough to make every mistake on your own, so you're still learning mistakes of others. We're going to try to be a repository.
That's right.
I did agree to do this. I see so much on her plate. Do this for you guys. And I got a round of applause for
Thank you all so much. Thank you. Thank you for your attention.